Good morning to those of you that are here already. We'll give folks a few minutes to join in before we get started. Okay, let's jump right in. Good morning. Again, my name is Michael Gault. I'm an eminent domain attorney with Bell Carrington, Price and Gregg. At Bell Carrington, we have an eminent domain group that specializes in representing landowners in eminent domain matters throughout the Southeast, particularly here in South Carolina, where I'm based. If you're here with us this morning, you know that we're here to talk about the 526 extension, which is also now known as the Clark Expressway Extension. If you're here watching this live, or if you're watching this later, there's a good chance that you're impacted by this project, or at least you live and work in the area and you're familiar with this project. And for most of you, you've probably been lifelong residents of this part of Charleston County. And because of that, you've probably been hearing about this project for quite some time. So let's look just briefly at the history of this project to sort of catch you up as to where we are now. Many of you, especially some of you that are lifelong residents, know that this project originally started back in the 70s, the early to mid 70s. The original plan for 526 was to have that extension run as a connector between West Ashley, Johns Island, and James Island. Obviously, in the 70s, that project didn't happen, and not much happened on it during the 70s. But let's fast forward to 1995. That was when we had the first draft supplemental environmental impact statement, or DEIS. That environmental impact statement is something that the DOT in South Carolina uses anytime they have a major road widening or new construction project like this one, to establish what the impact to the community and to the environment will be. And so the original environmental impact statement happened back in 95. That document was never finalized, and not much happened until 2004. Back in 2004, many of you will know that Charleston County voted on a 0.5-cent sales tax for transportation. That vote in 2004 was sort of the first initial attempt to really look at building this project. At that time, officials reached out to the State Transportation Infrastructure Bank for funding for this extension, and they couldn't get it because the infrastructure bank basically said, we think that if we give you the money, you're not going to be able to raise the rest of the money to get this project completed, and we'll just be wasting money. So fast forward again to 2010. That's when I first moved to Charleston, and that's when this project really took the next big leap forward. There was another draft environmental impact statement prepared in 2010. They did some more work at that time. They looked at a number of alternatives for this project and a number of alternatives of routing for the roadway. Ultimately, they did decide on an alternative in 2010, and that was known as Alternative G, and that's still where we are today. And that's basically a new 9.5-mile roadway, which 7.9 mile long parkway with an additional 1.6 miles of connector roads and bridges over the waterway. Back in 2010, we really thought that this project would get kicked off, that construction might start, that right-of-way acquisition might begin, but that didn't happen. And really nothing happened again as the project sort of died until 2019, when what we call the restart really began. Really early 2019, the state was able to put together a number of funding sources. Those included Charleston County. It included the State Infrastructure Bank. And those funding sources came together to sort of revitalize this project. It became known as the Clark Expressway Extension at the time, and that leads us up to where we are today. So, at every stage in that process that I just mentioned, there was an environmental impact statement. The one in 2010 was determined to be too old when the project sort of kicked back off in 2019. And so there was a supplemental environmental impact statement prepared that has since been finalized. And right now we're sort of in a permitting period, a period where permits for the construction from the Coast Guard, from the Army Corps of Engineers, all of these agencies have to review the plans and the permits and approve those before the next step in the process. But that's where we are now. If you're in the Charleston area, you know that Charleston County recently voted to approve funding for this project. That was back in late January. And so everything tells us that the project is moving forward, and it's moving forward rapidly to a time when later this year and early in 2024, right-of-way acquisition will begin. And that's really why we're here today, is to talk about that right-of-way acquisition. Naturally, if you're going to build a new roadway through areas that are previously undeveloped with a roadway, then landowners are going to be greatly impacted. The state, the SCDOT in this case, will need to acquire new land from landowners to build this roadway, and from existing landowners where there are existing roadways, they may need more. That additional right-of-way will be obtained by the state through the theory of eminent domain. And you may ask yourself, what is eminent domain? That is the legal theory that the government can take private land for a public purpose. In a case like this, particularly in a roadway construction, there's very little argument that the state will have the legal authority to take the land under the theory of eminent domain, because it likely will meet the test of being a public purpose. But as a landowner, you still have rights. Among the most important of those rights is the right to just compensation. And what does that mean? Well, it means that if you're impacted by this project or another like it in South Carolina, you have a right to be fairly and adequately compensated for not only the land or the property that the government seeks to take, but any damages that might result to what's left over after the taking. And that's sort of, where we come in to help guide our clients through the eminent domain process, and to ultimately make sure that they're protected when it comes to determining what is just compensation. This process, once the right-of-way acquisition kicks off later in 23 or early in 24, the way that will work is that the state or state representative of the DOT will reach out to you if you're an impacted landowner to let you know that you're impacted, how you're impacted, and ultimately what they're going to offer you for your impact. It's important for you to know that you don't have to accept that offer. That process for landowners can oftentimes be scary and a little bit intimidating, just because the people that reach out to you will be well versed in eminent domain. They will know the process and the procedure. They'll know the language. They'll know the players. They know how the process works. And oftentimes landowners, if you're impacted by something like this and you're involved in an eminent domain matter, it's probably the first time that you've ever been impacted. It's probably the first time you've ever heard many of these words, and you certainly don't know the process and the procedure. And so again, at Bell Carrington, we focus on helping landowners through that process, and we encourage you to reach out to us to know more about how we can help you. I've mentioned now a couple of times that the right-of-way acquisition process probably won't happen until later this year or early 24, but that doesn't mean that you don't need to reach out to someone now. It's never too early to take action. While we are in the sort of final design phase of this project, there are still design changes that can be made. So for instance, if you're a residential landowner or a commercial landowner, and we were able to get together to see that the impact to your property is extremely great. It's greater than average, and it is something that might shut you down. But there's always a chance that we could get together to reach out to the DOT's representatives to see if there's anything that can be done to help save your property or to save your business. Now, there may not be, but if we wait until later on in the process, the chance that we're able to step in to help you lessens even more. So this forum is really not meant to dive down into the property level, to the parcel level details, but more just to give a general overview of the project. It's certainly not meant to provide legal advice. I can't do that in a public forum like this, but you see our contact information over in the chat box, our phone number and my email address. And our team is standing by to speak with anybody who may be impacted. If you think you're impacted, feel free to reach out to us. We're happy to sit down and have a consultation with you one-on-one. At Bell Carrington, we're fortunate enough to have an in-house software that allows me in real time, while we're on the phone during that initial consultation, to pull up your property to find out if you're impacted, and if so, how you're impacted. And that way we can have an open and honest and intelligent conversation about how I may be able to assist you going forward in this project, to be able to tell you generally what the impact of your property might be, and what that process might look like going forward. And at that time, then we can have a discussion about what the potential attorney-client relationship looks like, the representation relationship looks like, and how we can really dive into the process and get to the meat of the issues. I like to tell folks in eminent domain cases like this, oftentimes landowners are hesitant to reach out to an attorney or to a law firm because, law firm fees, attorney's fees are normally expensive, normally prohibitively so. So that's not the case with eminent domain cases. Two things I can tell you. The first is that our initial consultations are always free. We encourage you to reach out to us. We like to speak with landowners. Even if you're not impacted, you're not wasting our time by letting us find out if you actually are. And again, if you are, we like to dive deeper to find out what that impact really is. Never any charge, never any cost for those consultations. They're always free. The second is that there's, in eminent domain cases at Bell Carrington specifically, we don't charge upfront retainer fees. There's never any out-of-pocket retainer fee due, never any out-of-pocket attorney fee due. Instead, we operate on what's known as a contingency fee basis, and that's ultimately a percentage of the just compensation that we're able to recover for our clients. I can't speak specifically to that, to the way that the fee structure works for every property in a public forum like this. It's just too generalized, and the process varies too much on a case-by-case basis. But again, you see our contact information, and I invite you to reach out to us to find out if we can help you, how, and then I'm able to discuss the specifics of those fee arrangements on a case-by-case basis with each of you. This project specifically is controversial. If you live in the area, if you're impacted, you know that. If you were at the county council meeting, you know that. If you read the news, you know that. But all indications are that the project's going forward. There'll be a number of you that are impacted. There'll be, the vast majority of you are going to be residential parcels or vacant land parcels across West Ashley, Johns Island, and James Island, but particularly in West Ashley, at the intersection of River Road and then down toward Johns Island, where the project terminates, there are a number of commercial parcels that are impacted. And the impact to those is often greater than those to residential parcels. If you're a business owner in the area, we certainly encourage you to reach out to see how your business may be impacted. There are lots of intricate details when it comes to commercial impacts that business owners often overlook, and we would like to have the opportunity to sit down with you to make sure that you don't miss those. So that wraps up about all of the information that I have on the project. Please visit our website, bellcarrington.com. We have an eminent domain lending page. You see my email and my phone number there. Please reach out. Let me know if I can help you. I look forward to speaking with you, and thank you for joining us.